Hello, Dan Marr here from Hamlin Carrigan. I'm going to be talking to you today in this about boundary disputes. You may be in a situation with a neighbor, either a new neighbor or an old neighbor, somebody you've had for a while that's done a survey and they're telling you that your property is on a portion of your property, whether your garage, your driveway, a portion of your land, backyard, front yard, is on their property, and they're asking you to remove it. Maybe they're telling you to even move a fence. There's the survey regulations and how they come up with the survey, and that tells you actually what in the field, in the registry of deeds, the actual title is, but use of the property matters. You might have, there's a variety of legal theories out there that matter a lot, called adverse possession, boundary by agreement, boundary by acquiescence, or boundary by estoppel. So the relationship between your property and your neighbor's property, including those who are before you and before your neighbor, matters. Adverse possession itself is a claim upon which, if you were not the record owner of this particular property, but you adversely, continuously, uninterruptedly used that property for 20 years, and that was such to show that you actually were claiming ownership to it, you can be successful in going to court, and you have to go to court for this, but going to court and being able to prove adverse possession, and therefore you're the record owner. And then the judge would actually issue an order saying, this portion of the property that is you don't own by record, now you do own by adverse possession, and that gets recorded in the registry of deeds, and now you have title to that property. So the house, the portion of your house, your garage or your side yard or backyard doesn't get taken away from you. So that's important to consider. Adverse possession itself can be a situation upon which both you and your prior neighbor during that 20 years thought that you were using that property up to the proper boundary. So you can be in a situation where somebody's, you're mowing your lawn and you're mowing up to a certain boundary, and your previous record owner says, yeah, when he was mowing the lawn, I thought that's what he was mowing up to his property and I was mowing up to my property. In that situation, the mowing of the lawn is probably going to be, or will be, good enough, because you're going to have a boundary by acquiescence, boundary by agreement, and enough for the adversity to show when this person is taking that step, the record owner actually thought that they were claiming ownership, because they both thought that that's where the ownership was. And I've had a case that went up to the Supreme Court that specifically stated that when representing one of the adverse possessors. So in that situation, a mowing of the lawn is enough. If it isn't that situation where the record owner is saying, when they're mowing the lawn, I thought they were mowing up to the boundary, mowing is probably not going to be enough. Mowing, or even perhaps a garden, may not be enough for adverse possession. A fence is a good example of something that's adverse possession. Telling somebody that they're on their property and asking them to leave would be a good example of adverse possession. But you need some steps beyond just a mowing of lawn. You can well think about the situation where you're taking your sit-down lawnmower and you're doing a swoop, or perhaps you're even going further to take care of somebody, take away somebody's crabgrass so it doesn't come into your yard. The court's not willing to go as far as saying that mowing of the lawn gave the record owner enough notice that it was adverse, unless the record owner said that. And I've had situations where the record owner for 20 years, before they sell to this new guy who's claiming, that gets a survey and says, hey, wait a minute, get off my property, that previous record owner testified that, yeah, I thought that that's where the property line was. And in that situation, the adverse possession can win. If you're the record owner and you're concerned about that, permission cuts off the 20 years. So you can be in a situation sometimes with summer camps or the like where somebody's using your property, you're concerned that they might be later on claiming ownership to that property. You can put in writing a notice to them saying, this is my property, I wanted to clarify to you, but I want to be good neighbors with you, and I'm fine with you continuing to use it right now until we say otherwise. You have permission. That blows the 20 years for them. They don't get the 20 years. So that's something to consider. Think about the issue of what your neighbors say in the past as to boundary by estoppel or boundary by agreement or acquiescence. Basically, if the surveyor tells you that you have a problem with the survey, just don't take that as the complete conclusion of this. Go to a lawyer that knows this issue. I've litigated on both sides of this issue. But the ideas of adverse possession or other arguments like that we just talked about can be a good defense, notwithstanding the survey.